Good afternoon, everyone. Hello, my name is Attorney Joy Farrell. I'm the managing attorney here at the Farrell firm, where we focus almost exclusively on the areas of family law. And family law includes divorce, child custody, child support, adoptions, etc. We also do personal injury here at the Farrell firm, so keep us in mind if you ever have any accidents where you are injured and need representation. To learn more about myself and our team here at the Farrell Firm, you can visit our website at farrellfirm.com. And on the website, you'll also find information about questions you may have about our practice areas. You'll learn more about us as individuals, and you can also schedule an appointment on our website should you decide you want to come in to meet with us. Today, we're going to be talking about understanding divorce and all the issues that you have to deal with if you are thinking about filing for divorce or if you are in the middle of a divorce. As I go through this, please feel free to type your questions below, and I'm going to answer every single question that I received during this live broadcast. To those who view this later, you will also get responses to your questions. I'm just going to have to go in after I'm done and read your questions and then answer them. So it won't be right away, but it'll be once I see it, I will make sure that I give you a response to that. So before we get going, let me give you this disclaimer. By tuning in today, you acknowledge and understand that any information given today is that of a general nature. Every person in every case is different, and you should feel free to seek legal advice if you need specific legal advice about your case. Nothing in this broadcast shall be construed to create an attorney-client relationship, and nor should any conflicts be created in the event your boo decides to hire us before you do. Okay, so let's go ahead and get started. And let's talk about divorce versus legal separation. So you're married and things aren't going too good, and you're thinking that you want to make your exit soon. So it's important that you be well informed on the law and know what your options are. The first question a lot of people ask me when they aren't quite sure if they really want to take the step of divorce is whether or not the state of Georgia allows for legal separations. The answer to that is yes. The state of Georgia does allow for legal separations. However, the correct term in Georgia is actually called separate maintenance. So if you Google legal separation, you may find something that says we don't do legal separations here, but we do. It's just called something else, and that's separate maintenance. The next question I get after people find out about separate maintenance is, how is that different from a divorce? And I always tell people that a divorce and a separate maintenance are like twins, identical twins, that are they almost look exactly alike, except one little thing is different, like having a mole, kind of like Tia and Tamir. So you can do the exact same thing in both actions. You can determine custody, child support, spousal support, division of property, assets and debts, etc. However, at the end of the divorce, the marriage is terminated completely. And at the end of the separation, you are actually still married. Some people may choose to stay married for religious reasons, or for the purpose of enjoying marital benefits, such as being able to file taxes jointly, or sometimes people may have health concerns and they need to remain on a spouse's insurance policy. And so in order to do that, you would need to remain married, because once you are divorced, your spouse would need to remove you from any health insurance policies within 30 days of that divorce. Some people also use the option of a legal separation for a wait period to see if their spouse will get their act together now that they've actually gotten official legal papers. For some people, it's the way for their spouse to know that they're serious about possibly ending their relationship. And so this is a good way to explore that, because at the end of the separation, and I say end lightly, meaning whenever you decide you want to resume life as regular husband and wife, you can do that. And you don't have to file any papers to dismiss the legal separation. You just have to start back acting like husband and wife. However, when you do a divorce, if you want to get remarried, you have to go through the process of getting remarried again. Legal separations can be beneficial, but sometimes they are not beneficial. So you would need to explore whether or not that's a good thing for you. So everything I mentioned today about divorces can also happen in a legal separation. Divorce. Where to file. When you are filing a divorce, you should file in the county that your spouse lives in. However, if your spouse moved out of your home less than 6 months ago, you can file in the county where the marital home is. And the marital home is considered the location where the two of you live together as husband and wife. So if you lived in DeKalb County and let's say the husband moves out to Gwinnett County, you can file in DeKalb as long as you don't wait longer than 6 months. But if you wait longer than 6 months, you're going to have to file in Gwinnett County where the husband moved to. Once you file the papers, you must serve your spouse. You must legally serve your spouse a copy of the divorce, because they have a right to know that they are technically being sued. In order for a service to be proper, the sheriff actually has to deliver it to them, or you may hire a private process server. Some counties require you to file a motion for a private process server before you can use one. So a lot of times the first step is automatically the sheriff's department. If you do not serve your spouse in one of these two ways, service is not proper. It is not appropriate for you to hand your spouse papers and think that service has been made. It is not appropriate for somebody else to give your spouse the papers. You can't send it in an email. None of that would be proper. And if you attempted to do that, your case would be thrown out for improper service. So once a divorce is properly filed and served on your spouse or you, there's going to be a 30-day period that is allowed for the answer and counterclaim to be filed. An answer to a divorce is an opportunity for either your spouse or yourself, depending on who received the papers, to assert your claim to the divorce and what you think should be addressed by the courts. And you have 30 days to do that. There's a little bit of a wait period, so make sure you timely count that deadline once you receive the papers and file it in, not a day late. Okay. Next, for you to be able to get a divorce, there has to be an actual legal reason. So there's 13 statutory reasons in the state of Georgia that you can qualify for a divorce. But don't worry, if you can't find one that qualifies for your situation, there is a catch-all reason, and that's known as irreconcilable differences, which means you and your spouse just can't get along. So going over the grounds for divorce, some of those may be cruel treatment. So that's if somebody is obviously abusive to you. That can be verbally or physically. Abuse, incarceration to prison for 2 or more years, incurable mental illness, habitual intoxication, or if your spouse has a drug addiction, those would be valid reasons for filing a divorce. Abandonment is another ground for divorce that people like to try to assert. However, if you file for divorce under abandonment, the abandonment has to be for at least a period of 1 year, and that year must be consecutive. So if your spouse left last month, they have not been gone long enough for you to file a claim of abandonment. If they were gone for 11 months, came back and lived with you for a period of a few weeks, and then left again, that then broke the 12-month consecutive cycle, and it would have to start over. So you would not be able to assert a claim of abandonment. Adultery is also a ground for divorce, and that's when one spouse has an extramarital affair, and that affair is the cause of the divorce. And what I mean by this is if your spouse cheated 5 years ago, you found out, you guys got over it, and you continued living together as husband and wife, adultery wouldn't be the proper grounds to assert for your divorce, because essentially you forgave them when you started resuming your relationship as husband and wife. And so if you're going to file for adultery as your grounds for a divorce, typically you find out about the adultery and then you move forward to a divorce sometimes shortly thereafter. Now, when considering what to file in your divorce papers, you need to remember that divorce is a public record. So everything that goes in the file is open to the public, and anyone can view that file at any time. So you want to be mindful about putting too much detailed information in the pleadings. And so a lot of people just like to keep it generic. And when we keep it generic, we just go under that catch-all phrase I told you about, which is irreconcilable differences, which basically means one or both of you are no longer willing to continue their relationship, and there's no hope for reconciliation. Another issue that comes up when people are seeking a divorce is fear that the spouse won't comply. A lot of people say, well, he or she says she won't sign anything, they're not going to come to court, etc. Will I be able to get a divorce if they don't want to get a divorce? Well, in order to get a divorce, no agreement is required. If you want a divorce or your spouse wants a divorce, there is nothing you can do to stop it. It takes 2 people to get married, but it only takes one person to want to get the divorce. Someone saying that they will refuse to sign anything or refuse to come to court doesn't mean anything other than they're being negligent. While one may choose to ignore divorce pleadings, it is not wise at all to do so. So if you get served with divorce papers, you need to respond to them. Even if you don't want the divorce, you need to assert your interest by filing a proper response. So once divorce is going forward in the courts, division of assets and debts is a big thing that's usually discussed in the divorce. And this is basically discussing it's something if you earned it during the marriage, if you bought it during the marriage, it's a marital asset. And the court has to determine how to divide those assets or debts. Your bank accounts, if you have money in those accounts that was earned while you were married, it is marital property. It doesn't matter if your name is the only name on the bank account. It doesn't matter if your spouse does not know about the account. It is subject to division by the court because that money is marital property. Your retirement accounts, any money that has gone into a retirement account is marital property and subject to division. Even if you're the only one that has worked, your 401k, 403b, IRA, pensions, etc. are subject to division by the court. It is marital property, even if your spouse never contributed a dime to that account. So that's a common misconception. People don't want to split up their money because they feel like it's theirs. But when you're married, what's mine is yours, and that is a true statement. Your houses, if you purchase a home during the marriage, it is subject to division. If you purchase your house before the marriage, but your spouse has contributed to improving the house or paying for the house in any way, then they may have a partial claim of interest to your home. So that too must be divided by the court. And that's your house and any other property you have. If you own land, timeshares, etc., all that goes under property. What's important to know about the state of Georgia is that we are not a 50-50 state. We are an equitable division state, and what that means is that our courts divide assets equitably, and that is not necessarily equally. Instead of 50-50, our courts could do 60-40, 90-10, 0-100. It just all depends on the factors of your case. So a lot of times people get in the mindset of, I want half is mine, half is mine. That is not true. In the state of Georgia, half is not necessarily yours. So you actually need to seriously get a lawyer to be able to advocate what you would be entitled to after you get some legal advice. Divorces also, of course, handle child custody. Any children born of the marriage are not subject to division per se, but child custody does have to be determined. I really want you guys to know that if you are still married, but you are separated, you and your spouse have equal rights to your children. This means that if one person moves out, no one should be dictating or controlling who and when the kids get to see the other parent. If you're married, the parents have 100% equal rights, and no one is in a greater position to make that control of authority. Unfortunately, sometimes in divorces, it's whoever beats them to the punch. If dad ups and leaves with the kids, they live with him. If mom ups and leaves with the kids, they live with her. The kids have to live with somebody, but what I'm trying to convey is that as long as you're married, you and your spouse need to make sure that the kids are getting good parenting time with both parents, and stop trying to dictate, oh, you only get weekends or you only get these certain days, because a mom or a dad can go up to the school, they can take their kids out of school, they can keep their kids, they can do whatever they want to do. It's not any type of kidnapping. If you are going through a separation, in an unofficial separation where you haven't filed for divorce and you're having issues with child custody, then you probably need to go ahead and file for divorce so that you can get some relief from the court. Divorce will also address spousal support if it is needed. Spousal support is also known as alimony. In order to receive alimony, there must be a need for alimony, and then the spouse must have the ability to pay that alimony. No one cares about lifestyles and how fabulous life was while you were together. In the state of Georgia, we look at the need of the alimony and the ability to pay. That's it. So if you have an education, if you have a history of working or the ability to work, you should not expect to receive alimony, or if you do get alimony, it won't be forever. Alimony, in my opinion, is a dying phase here in the Georgia courts, absent special circumstances. So be very mindful about preparing yourself for a separation or a divorce. If you are going to be the spouse who's in financial need, you really need to be strategic and plan yourself, save money so that you're going to be able to support yourself until the court can get you some type of resolution. So you may be able to get those retirement accounts, but it may take you a year to get money out of those accounts to be able to take care of yourself. So you should be looking at trying to find a job or doing something. Speaking of spousal support, cheating equals no alimony, no spousal support. In Georgia, cheating is an absolute bar to alimony. So if you were the one who cheated, the court will not grant you alimony so long as the cheating was the cause of divorce. So if you are the higher earning spouse, or if your spouse is not working and you discover that you're cheating, that would be a good time to file for divorce, because that's going to bar the alimony claim. You can't reconcile the marriage and then come back later and say, oh, well, no, they cheated, they can't get alimony. If they cheat, divorce them. That'll bar the alimony at that time. Okay, so that was a brief overview of divorce, and I'm going to likely do another video on divorce in the future, because it's so much and goes so much in detail that I can't possibly do it in a timely manner today. So if you have questions, start typing them now so I can go through and answer them live. And while you guys are typing your questions to me, I'm going to put up a few questions that I received on some other Facebook posts and answer those. And then hopefully by the time I finish, you guys have put your questions up so I can go ahead and answer those. So the first question is, how can we divide our home if my husband wants to keep the house and I plan to move? So this is a good question, and it usually happens like this. One spouse is going to keep the house, the other spouse is going to move out, but the spouse is entitled to some of the equity. So what we look at is the equity that's in the home, and then we divide the equity portion. So just to keep numbers easy, let's say you own a home and you owe $100,000 on it and it's worth $50,000. That means it's $50,000 in equity. And so if one spouse was going to be leaving, that spouse will be entitled to a portion of the $50,000 in equity. How much will depend on the party's agreement or the court. If you were to go with the 50-50 analysis, it will be $25,000 buyout of equity in that home. So that is how you would go about doing that. So you want to make sure you get the house properly appraised. And if the spouse that's staying in the home doesn't have $25,000 or so to buy you out, the spouse could refinance the home and do a cash out on the refinance to get you your portion of the money. My wife moved out with the kids and tells me I can only see them when she allows. What can I do? If you're still married but living separated and you're not able to see your kids, you need to go ahead and file for divorce. That way the custody can be determined. The longer you allow something to go on, let's say you don't see your kids at all, it's going to be very difficult during the divorce proceedings to show that you wanted to be an active parent in the kid's life when you didn't do anything to make sure that you were going to be able to see them. It's not enough to say, well, she wouldn't let me. Like, we're all adults here and people don't tell us what we can do, especially when it comes to our kids that we have equal rights to. So if you want to see your kids, you should act sooner than later. I've been separated from my wife for 4 years and I don't know where she is. How can we get a divorce? This is extremely common. People they break up marriages like they break up boyfriend-girlfriend relationships and just leave each other and change phone numbers and don't talk to each other. So if you've been separated a long time and you have no idea where your spouse is, you can still get a divorce, but you're going to have to serve it via publication. So what I've talked about first is that service is absolutely required by the sheriff. But if we don't know where they are, we have to serve it in the newspaper. So what we'll do is send it to the newspaper. We'll run it for 30 days, and then they'll have another 30 days to respond in the event they see the paper. Most people don't. So it's about a 60-day process. Once it runs through the newspaper for that time period and they have a time to respond, you can go ahead and proceed to court to get the divorce on your own. My husband moved out of state. Can I file for divorce in Georgia? Yes, you can file for divorce in Georgia if you're not seeking any other relief, or the courts would need to have actual jurisdiction over your husband. So if you're just looking for a straight divorce, you're not trying to divide assets, get alimony, child support, etc. You just want a straight divorce, say y'all have no kids, no property, then yes, the state of Georgia can issue that divorce. So now I'm going to go into your questions here. I'm going to start with Latanya. Thanks for doing these sessions, especially for those who cannot afford attorneys or the price for consultation sessions. Legal aid only helps if there's domestic violence. Well, you're welcome. This is exactly why I do this, Latanya. So let me see if you ask me questions. Yes. How do we serve when the spouse has evaded the state? So Latanya, depending on how long ago they evaded the state, if they lived in the state of Georgia for a period of time and we only know what their last address was, we could file in the county where they last were or publish a notice in the county where they last lived, that publication notice, and go ahead and proceed forward with the divorce that way. What proof do you need for adultery? Well, in the world of social media and text messages, just a little bit. I mean, there's some text messages, pictures, posts. You don't have to go hire a private investigator or anything like that. But you do need to be able to prove it if you assert it. If you saw something with your eyes, your testimony is technically sufficient. So as long as your husband doesn't try to refute that claim. But depending on the circumstances and what you're trying to get in your divorce, and if I feel like we can't prove it, I might say, hey, it doesn't make a difference here if we say adultery or not, because we're not trying to do this, we're not trying to do that, we're just trying to get you divorced. And if he cheated, that's unfortunate, but it's not going to change the factors of your case. And so you may not need to prove it. You may just need to go under irreconcilable differences. Latanya also asked, what happens when a spouse quits job, takes the retirement money out before the divorce is even filed, but already separated? So Latanya, it sounds like you're unofficially separated. I'm not sure. I don't see this question popping up on the screen, but he's still, that retirement money is still marital property. So we would be able to go back and try to get an accounting of what was there and still try to get you your money that way. So it is a no-no to pull assets, remove money from bank accounts, transfer money, transfer houses to your friends and all that because you know a divorce is forthcoming. And as a way to hide assets in a divorce, that's a sure way to get yourself in a lot of trouble. Oscar, will I get a tax penalty for giving my wife some of my retirement? What we have anytime there's an exchange of retirement is called a qualified domestic relations order. And that's the only way that retirement assets can roll out via a court order and not be penalized. So Oscar, what it would do is that it would roll from your retirement account into your wife's retirement account or a qualified account. So she can open up any qualified retirement account. There will be no penalty on either of your ends. Now, if she didn't have a retirement account, she just wanted to cash out her your money that came to her, she would receive a penalty on that for not putting it into a qualified account, but you would not have to pay a penalty. Once the divorce is final, can we go back to modify the divorce? Once the divorce is final, there's no do-overs on a divorce. Only things that are modifiable after a divorce decree is child support, child custody, and alimony. If it's not one of those things, it's not modifiable. So the house can't relitigate it, can't relitigate retirement, can't relitigate personal property or anything like that. So you want to make sure that you include everything that needs to be included at the time of the divorce, because once it's done, no do-overs. Can I kick my wife out of the house before doing a divorce? No, you cannot, even if she's not on the mortgage or lease or whatever. If you guys are married, you cannot evict her. She doesn't have to leave. She has just as much right to be there as you do. If my home was purchased before the marriage and my spouse abandoned me, it's my home and I'm seeking a divorce. It's been 4 years. I know where he works. Am I entitled to spousal support and have him pay for legal fees as well? Audrey, okay, if your home was purchased before the marriage, that's called premarital property, so you wouldn't have to worry about splitting that up in the divorce. If it's been 4 years, you're not going to be qualified for alimony because the argument is, hey, you've been taking care of yourself for the past 4 years, so you can continue to take care of yourself. You may be able to have him reimburse some of your legal fees depending on what his income is compared to yours. Okay, it doesn't look like these questions are, oh, I know why they're not showing up. Okay, I'm going to make sure you guys are listening to the questions because they're not showing on the screen, but I see them on my end. So Amy says, if you have a restraining order out on your husband, how do you get child support? So Amy, you can file a petition to establish child support. If you go to our Facebook page, we have a video called Understanding Child Support Part 1 and 2. It goes into great detail about that, but you just file a petition. You can have him serve the restraining order. Won't matter in that situation as far as you being able to get child support. Amy, if you have a restraining, oh, no, I already did that one. No. Oh, you can see them. Thanks, Vina. Do the children ever have a say as to whether they want parenting time with the other parent? Latanya, the kids need to be 14 or older to make that say so. If they're younger than that, then they don't have a say so about that. Okay, I think I have answered everybody's questions. I'm just gonna scroll one more time to make sure I answered everything. Okay, I think I got everybody. So I just want to thank you guys for tuning in with me this afternoon. We do offer consultations here in our office, and they are $150. If you would like to book a consultation, you can give us a call, 678-973-2803, or you can book online on our website. I hope you guys have a wonderful Friday afternoon and have a blessed weekend, and I will see you guys next week.